And thank you, everyone, for joining us for this edition of IP Watchdog Unleashed. This week, we have a special guest, Jason Harrier. Jason's a friend of mine. I've gotten to know him over the last several years. First met Jason when he was at Capital One, Chief Patent Counsel, Capital One. And then he moved from Capital One to Plaid, which we'll have him talk about and ask him to tell us why he did that and what Plaid is. And then he recently moved on from Plaid, and now he is at IP Copilot, which is an AI company that some of you probably are familiar with that does work for us patent attorneys and innovators in our space. It's an exciting time. So Jason, happy to have you here. Thanks for joining us.
Thanks, Gene. Happy to be here.
So I've actually wanted to talk to you in this podcast setting for a while, and we've kind of had it planned and then got to push back and so forth. But I'm glad that you're here because I just always enjoy our conversations, number one. But let's start and ask you to tell us, what are you currently doing right now? Where are you at? What are you working on? So people kind of get a sense of where you're coming from.
Sure. Thanks, Gene. I'm currently the General Counsel and a founder at IP Copilot. IP Copilot is an idea management platform. I've started to say that instead of an AI company, we're a next generation platform for idea management, patent management. And AI is a big part of what we do. Mission of what we're doing at IP Copilot is to help more innovators become inventors. And I think that mission aligns all the way from idea discovery to how do you get robust disclosure of ideas within enterprises, how do you share that, how do you curate which filings to make, and how do you get patent prosecutors during the application drafting process a head start so they can do their best work. And so we're an idea company. And we use a lot of AI, but not necessarily because it's AI, but because it's the best way to do things today.
All right, we're going to talk a lot about that. And while it came up, I think I'll just mention in case a big part of what you guys are working on now is invention harvesting. And I think you know Savon Kalmanoff. You've met him. He's head of I get to get his title maybe a little bit long, but he's essentially head of IP for Canon USA. And I asked him recently, I was like, look, if I was going to be putting together panels to attract in-house attorneys who want to attend, want to speak, what topics would be at the top of your list? And at the very top of his list, and every time I ask him this, is invention harvesting.
Yeah.
And you spent a bunch of time in-house at various companies. Yeah. Why is invention harvesting, for those of us who are on the outside, who don't necessarily understand the internal politics, the job functions, the time management for engineers and scientists, that sort of thing, why is invention harvesting such a critical? Well, we probably can understand why it's critical, and we can talk about that too. But why is it something that in-house counsel are always looking for what's next? It seems like it's one of those things where this is the way we used to do it, this is the way we're trying to do it right now, and this is the way we hope to do it in the future. I mean, what's driving this issue for them?
Sure. That finding the best ideas within an enterprise is one of the primary goals of anybody in-house. And it's one of the last areas that technology has really touched. It's gotten a little bit better since the pandemic because a lot of folks are working remotely and you can connect with folks more easily on Zoom than you were able to before. But it's still a very manual process to go from a small patent department into a huge enterprise. And as an example, when I went to Capital One, it was my first in-house job. I had worked with inventors, obviously, a lot in firm life, but I had never been in charge of finding ideas from them. And my initial impression and thought was that I'm going to go and we're going to educate the inventor community as step one. And we're going to let them know that we have this really fun patent program, and we're going to let folks know that we're here. You can get a patent bonus if you submit your ideas. And then we're going to move on to step two. The reason, and then a short answer to your question, is that step one never ends. Because inventors, I have a phrase I always say, like, never get attached to an inventor. And no matter what enterprise you're in, you're going to end up with prolific inventors that you really like working with, but they always move on to different teams, to different companies, and ever more The culture these days is to not stay at companies as long as you used to, and so there's constant attrition and turnover of your inventor community, and there's different goals. Different business units have new leadership to come in. There's lots of reasons, but the education never stops. And so that's why it's challenging, because you have a small patent department relative to an organization almost all the time. So at Capital One, we had approximately one patent counsel for 10,000 employees. At Plaid, I was 1 to 1,200. And that's typically the case. If you go to any large organization, you're going to have 1 to thousands patent attorneys. And that's a lot of ideas to try and get. And the other reason it's difficult is because there's so many ideas. This is a great problem to have. But so at Capital One, after we had our program up and running for a while, I used to go out and talk to 100 people, 200 people at a time. And I had this graph, and it was a hockey stick graph of the ideas that we were filing for patents. And I used to tell them, I said, look, in 2017, we hired a new patent team. We generated a new program. There's a lot of excitement around it. We have the best swag. We have a lot of fun. We did a lot of things to build this program, but the one thing that we didn't do was go out and hire a single person just because they were a prolific inventor. And all of these ideas, they all came from you. We just started to find them. And that's kind of the beauty of it, is that everybody has great ideas. Everybody is an innovator. Everything in this room started as an idea. And so trying to find all of those, I call it dark matter within an organization, is extremely difficult because you have a small group looking for, almost unlimited ideas within an enterprise.
So that's fascinating. I mean, let me dive into that a little bit. I want to talk to you about Capital One and Plaid too a bit, but since we're going down this path, let's chase it a little bit.
Yeah.
How often do in people who qualify as inventors, whether in some institutions it'll be scientists, some institutions it'll be engineers, and some institutions encourage everybody with an idea. So, but how often do your inventor community, your inventors, move jobs today? I mean, is there like a rule of thumb? I've heard some enormously short lifespans, people moving, companies hopping, and in some of the hiring we've tried to do at IPWatchdog, looking at resumes, it's like people don't even stay a year anymore.
Yeah.
We had an employee here at IPWatchdog that we really liked. We offered her a raise to keep her happy, and she left 50 weeks after. She didn't even wait for her 1-year anniversary.
Yeah.
Just because she wanted to see what else was out there. And I think it's a different world. But is there a sort of a rule of thumb, like you're going to lose your inventors in X number of months or Y number of years?
I think if you're looking at the younger generation, the folks that are a lot of the engineering students that come out of school or who gets hired, and I'd say 24 months is around average, and sometimes longer than normal, so 18 to 24 months. I found that a lot of the younger folks culturally are doing jobs not as a job, but it's a project. Like they come to the company to work on a project. And when they have that project under their belt, they've shipped it, then they don't necessarily stay at the company for the next project at that company. They find the next interesting project to look for, and then they'll go to a new company to work on a new project.
So we're both in the greater DC area.
Yeah.
And that mentality's been around here for a long time because there's a lot of people that work for, this agency or this subcontractor on this contract and this project. They're there for a year or two and then they move. Sometimes it's even 6 or 8 months.
Yeah.
And then they move. What's interesting is I think that mentality that has always sort of been the DC subcontractor mentality is becoming pervasive.
Yeah, it's getting a lot more popular in regular private enterprise, especially in the inventor community, the product, the tech, and the design folks. And that's totally contrary to the way that I grew up and the way that I went about things. Like I started practicing, my first job was at the patent office, and then I worked at a small boutique, and then I worked at Kenyon & Kenyon right at the beginning of the financial crisis of 2008 and 2009. And that was when we were checking above the law every day to see like which firm was laying off how many folks. And so my entire career I've operated under the assumption that I'm about to get laid off the next day. And so I'm not, I'm trying to, that's the way I think. And like you're trying to stay, not necessarily for a project, but you're staying as long as you can. And now there's this culture of really frank discussions that I've seen in big enterprises where someone will go to their manager and say, I'm looking to leave at the end of the year. And they'll say that in like February. And I would never dream of telling somebody I'm about to quit in 11 months.
No, I know. I mean, well, in our space, you almost really can't. If you have access to any kind of innovation or trade secrets or things like that, I mean, because the minute almost that you say that, you have to be ushered out the door.
Yep, exactly.
And people, I mean, I just, and I know this wasn't something that we thought we were maybe going to be talking about, but I just don't understand what's behind that. I don't know how people can live like that, like hopping from job to job. And because what I do see in looking at a lot of resumes, there are gaps. It's not like you wait until you get a new job. It's like you jump not knowing whether you have a new job.
Yeah.
And I mean, even if, health benefits, I guess a lot of these younger people, and I probably fell prey to this too, when I was young, thought you were bulletproof.
Yeah.
Nothing's ever going to go wrong. But you don't have benefits. You don't, and I wonder what are they doing, saving for retirement, or what are they doing, saving for now buying a house is out of the reach of a lot of people, certainly in this area and a lot of areas across the country at the moment. I don't know what this portends for the future.
It's very interesting. Some of the smartest, most prolific inventors I've ever worked with are now living the van life, driving around the country, climbing mountains. And there's something to be said for just getting out there and enjoying your life when you're young and you have less responsibility and can risk it. But they're not working at all in some instances, working part-time in others. And some of them are traveling the world doing travel blogs instead of like really gifted engineers and product folks are just doing totally different things. And so, I mean, on one hand, I get it. You're young, you can do it. You don't need necessarily that much money. You can go explore the world and do it while you can. But it's a different world than what I perceived when I was growing up, what I would end up doing. I never would have dreamt to do something like that.
No, me either. And as a matter of fact, we had one of our law professors talk to us about, delayed gratification. He's like, you folks here get that. You're here for 3 years. You're putting your life on hold in hopes that at the end of those 3 years, what you're going to be doing is going to be better. If not immediately, some of you will leave here making less than you made before you went to law school.
Yeah.
But that the long-term prospects are better. And so I've lived my life like that, working hard, building a retirement account, trying to have my house paid off by the time I retire, which probably any more retirement folks tell you isn't completely necessary. For me, in my mind, it's completely necessary.
Yeah,
it's a different way of thinking, this younger group, and I don't know what it is going to lead. And if they can make it work, good for them. But I worry. So when I see younger folks in my family, what I worry about is it's all good right now. Because if all goes wrong, like my son, if all went wrong, he's 28. He could get a moving truck and, put a sign up and people would hire him to lift heavy objects, or whatever the case may be, right?
Yeah.
At some point in time, that runs out. Your ability to bend over and pick things up for a living ceases.
Yeah.
And I wonder what that economy looks like. And that's why I think innovation and education are just so important, and I don't think in the U.S. we're doing either particularly well.
Yeah,
I mean, we spend a lot of money per student on education, and we're 40 out of 40 measured countries in the world, from what I understand.
Yeah,
and that's just pathetic. And on the innovation front, what's the solution? Is there any way to reach these inventors to incentivize them because they really do play an incredibly important part of our economy, and they make lives better?
I agree. It's difficult to reach them because they're always new, and they're when you join a new company, you're uncomfortable. You're trying to learn the techniques that folks are using to innovate at that company. You're trying to learn how to get ahead at that company, the new project that you're on, and so it does from like a patent and an IP perspective, it's more difficult. Because everybody's new or they're just about to leave.
Right.
And you're trying to do that. I think that overall, like as they're moving project to project and might be from company to company, I think they're still gaining innovative intuition, and they're learning about products and services. Part of the reason I think it's so easy for folks to move from company to company so easily is because in large companies and small companies, it's reorg after reorg after reorg. You have a new job no matter what.
Yeah.
And so you might as well go get the higher pay and get the easier promotion. Mm-hmm. Sometimes it's easier to get promoted when you go to another company. And so as long as they're like, for example, if you're at an AI company and then you go to the other one and then the other one and then the other one, you're still slowly learning about AI and you're still going to be innovative in that space, just not necessarily at the same company. And so you lose a little bit as far as the innovation culture, because it's going to be different at every company, and the patent program culture and the IP program culture, that will be different. And so you lose a little bit there, but I think you still can have a steady pace of innovation as folks move through company to company.
Yeah. So I want to, pivot, because I got a lot of things I want to talk to you about. But one of the things that we were been talking about just ourselves over the last couple of weeks, and before we started filming here today, was about the backlog at the patent office and how it has just really gotten out of control. Historic highs. It's 860,000 plus unexamined applications. I mean, it's just historic high. And then there's all kinds of other hundreds of thousands of applications in process. And there's just watching what's going on in the administration. There are government employees being let go, probationary employees particularly being let go, offers that were put out that have been retracted, and a lot of people are worried because it's like, for whatever reason, and I think we'll get an idea of why this is as people start looking, but the last administration, the patent office backlog just ballooned to record highs. I mean, it's just factually what happened. Why it happened, I don't know, but I have some suspicions why it happened. So we have to kind of try, I think, and address that, along with, because right now the Federal Circuit says that if your application is pending for more than 6 years, prosecution history laches is presumed. Yeah. It's like, well, I mean, at least half of every time I ask an attorney, at least half their docket is older than 6 years old. Yeah. So, and it's only going to get worse with the backlog being worse. So something's gotta give. I think one of the solutions, there's many solutions. I think one of them is that the examiners need to allow more patents. Like, we have a PTAB there. They're pretty aggressive at fixing what they perceive to be mistakes. It seems crazy to me to be spending as much time, money, and energy on the front end. And we also know that there's a lot of supervisors at the patent office that tell examiners, just come up with whatever rejection, no matter how ridiculous, no matter how bogus. Yeah. That's got to stop. And I think if that stopped, and then I also think examiners more by and large need to be working with applicants and identifying, well, I can allow that. I can't allow that, but I could allow this. And if you do enough of these things, maybe shave an hour or two off of their allotment until we get through this backlog, encourage them. If you don't find anything, you have to allow it, get it out the door. I think there's things that we can do. What impact that'll have, I don't really know. So then there's big talk about technology. And, and I know the Patent Office is interested in technology. Now, IP Copilot, the company that you've founded, has created, in my words, sort of like a effortless, brainless invention harvesting. Yeah. Right, where you feed your Slack channels, your email, any communication that's going on through this AI, and it identifies interesting ideas that then let the patent professionals say, oh, let's do more of that, or let's put these two inventors together. Feel free to tell us a little bit about that, but where I really want to go with that is you said right before we started that you think a tool like that could really benefit examiners and cut down the amount of time. So I want to get into that. Well, what tools can or should the office be using? So take it in any order.
Yeah, it's interesting. My first job out of law school was at the Patent Office in 3600 Business Methods Art Unit. And
so were you a no patent for you examiner?
I've never issued a patent, but I was only there for a year, and
maybe you get some, right? Because if you're only there for a year, you
I only had examined a dozen. You go through the academy and then you start. So I wasn't of the mindset that I wouldn't, but you do hear that at the patent office. I think by and large, patent examiners are trying to do a good job They have the tools that are given to them, and they're trying to work within their production requirements and the hours that they have to examine applications. But you do hear of art units that are difficult to get through, and kind of a culture of not allowing things in some cases. I think those are edge cases, but they do get a lot of, people hear about that a lot. And there's a lot of reputation that comes from a small group, I think.
Yeah.
I think that, so at IP Copilot, we set out to help make more innovators inventors. And so we're trying to discover ideas from folks within enterprises for the most part, help inventors seamlessly, whether passively by detecting ideas that they're talking about in Jira or Slack, or allow them to just drag and drop their work and then submit invention disclosures with one click. And so we're trying to get that discovery process as streamlined as possible so the innovators can get back to innovating. The part of IP Copilot that I think is really relevant to the patent office is, from my experience in-house, it's great that you have thousands of new ideas that you've discovered within your enterprise, but as a small team, one of the most difficult things to do is to curate your portfolio. And how do you make strategic filing decisions? Every decision is tens of thousands of dollars that you're making. And so how do you make that at scale in a responsible way when you're dealing with millions of dollars a year in a budget? And so I've been thinking about this a little bit more, and I think that the in-house counsel, with the right tools, are totally aligned with patent examiners at the patent office. There's a right answer to whether this thing is new, not obvious, meets the requirements for a patent application. And I don't think that anybody filing patents is trying to get anything through that shouldn't get through. They're trying to file something that meets all of the requirements and that they have some level of certainty as to what coverage they're getting. But as it stands right now, everyone's doing it in a fog. You don't really know. You have an idea, you know it's kind of important to your business. You don't have time to do a full prior art search. To the extent you do, you have outside counsel do it. They give you their best guess. You file a patent application. You claim the broadest possible thing you can claim, and that kind of starts everything off on the wrong foot.
Yeah.
Then the patent office is finding prior art that is teaching the very broad thing, but isn't even in your art area. Mm-hmm. But to their credit, it's true. Right. You claim something extremely broad. And so IP Copilot has a curation module, so that as soon as an idea comes in, we rank it, we give a proprietary score, but we're instantly doing a prior art search. We don't just do a prior art search, but we actually review all of the prior art with AI, and we tell you what is unique about that disclosure right up front. So when you're making a filing decision, you know exactly what you're likely to get out of the patent office after they do their search, because presumably the right answer is going to be on both sides.
So if I'm hearing you, what I think you're saying is that if examiners had access to a tool like this, then they would they be further down the line towards the examination? Is that what you're saying? Maybe cut at least an hour or two off of the front end as they're trying to understand what the invention really is? Or
yeah, I don't think AI is going to take over patent examination. I think of AI in all aspects, whether it's idea discovery to curating it to filing and drafting patents. It's an assistant to give you a head start, and it gets you to the gray area. Our entire profession is revolved around gray areas. Right.
And I wanted to stop you, but you were on a roll. But when you said, and your outside counsel gives their best guess.
Yeah.
I mean, and that's whether it's a 101 guess, whether it's a 103 guess, usually we're probably pretty good at 102. This has got everything. You're not going to get anything. But 101 and 103 have become, and for those who aren't patent people, that's patent eligibility and obviousness, have become so subjective.
Yeah.
That it is, at best, a guess.
It is.
In a lot of spaces.
And that's where AI is not going to do great, because there's a lot of law to take in, and there's a lot of advocacy. And whether you're doing patent prosecution or you're doing patent litigation or you're doing patent licensing, there's advocacy surrounding these gray areas. And it would be better, quality-wise and for the system, to focus on those gray areas. And then to the extent we can, let's fix those and make it more efficient. But there's a lot of areas like novelty. You can see whether something is taught in a reference or not verbatim. And what I think tools like IP Copilot could do for an examining court is you get a new patent application in. There is a manual out there that tells you what to look for to make sure it meets the requirements. AI isn't great at everything, the large language models that everyone talks about today. What they are really good at is reading documents and figuring out what those mean. And so they can take in the MPP, and there's a huge opportunity there for them to, when I was examining cases, look at the formalities first. Does the abstract have the right number of words in it? Are the 112 requirements met? And the AI would do a really great job of flagging those sorts of issues. And what we do at IP Copilot is we instantly do the prior art search and have a chart that has the features of the patent, and it has the prior art with the citations right there. That's a huge head start for an examiner to have that as your starting point.
Well, not only that, but like if everybody involved had that same information, right?
Yeah.
You know, so like if the examiner had this information, if the applicant had this information,
Yeah.
if the applicant's representative had this information, then you could have much quicker earlier conversations of consequence.
Exactly. You know, if there's 5 features, A, B, C, D, E, you know that C is the thing that you think is important, that you think is new over the prior art. You emphasize that in your application. Patent office should mirror that.
Yeah.
And then you can talk about C, and then you can move on in one office action,
Right.
rather than, you know, a 4 or 5 year prosecution period.
So the other, right, and I'm glad you mentioned that because that's the part that really bugs me about, you know, the patent office at times has been more or less, but more usually interested in compact prosecution.
Yeah.
And really pushing compact prosecution. We have nothing that even closely approximates, that comes anywhere near, doesn't closely approximate, it doesn't come anywhere near compact prosecution. We have long, slow, drawn out, tedious prosecution.
Yeah.
And and I'm not going to say it's just the patent office's fault for that. I think there's a lot of practitioners that are to blame, and there's a lot of clients that are to blame. I think everybody has some ownership in that. But it would seem to me like if you were drunk on a bet, you couldn't create a dumber way to go about prosecution, right? It's like if we were all here in the room at the same time and we all had access to the same information as to, okay, this is the prior art that we found, or at least this is the universe of prior art we're going to apply.
Yeah.
You know, and then we sat in the room and talked until we had an agreement, or talked until we got to the point where we realized, okay, no agreement is possible. Then move on to the next. I just don't see any reason for these. Even a fast prosecution is going to take 18 months.
Yeah.
And it's going back and forth and back and forth, and I have it in my head now because I worked on it for, 10 hours as an examiner or whatever, and then I put it away and I don't touch it for months.
Yeah.
Well, it's stupid. You did most of the work. Why can't we just finalize it right here, right now?
Yeah.
And and I would do the whole system differently. I think I would create a system where, when an examiner was working on a case, you would get an appointment with the examiner. The examiner over the last week has spent X, Y number of hours on this application. They're up to speed. You're up to speed. You wrote it. Or if you're not up to speed, send somebody who is up to speed on this day to this Zoom call or whatever we want to do. We could do it in person. We could do it via Zoom or whatever they want to use. And see if we can wrap all these things up and go on to what's next. It just seems like it's a screwy system. It's a legacy system. It's not a system that leverages technology in as meaningful a way as it could. And it doesn't seem to me that it leverages just good human interaction as well as it could.
Yeah, to your point about picking something up for a day and then putting it down for months. When I'm looking for outside counsel to draft patent applications, I have a 2-sleep rule. I think you can't replace a human being thinking about a problem, going to sleep, walking the dog in the morning, thinking about it, doing it again, and then going to sleep again, and then doing it again. You're constantly thinking about that, and whether you're subconsciously doing it or consciously doing it, you're coming up with something better over time, and you're processing it, and you're digesting that information, and you come up with a better result. And I think that's one of the reasons AI is not going to take over patent application drafting for a long time, because you can't replace that with AI. I also think that in the examination process, if you have someone spending 2, 3, 4 days on a patent application, and then the examiner has less than a day to look at it, and then in a matter of months you have a little bit of time again, you don't really have that same ability to digest it. There's not time to digest it. So I think it would be better to do. I think your solution would be great if you had a more in-depth process at once rather than spreading it out over time.
Yeah, and I thought that's what I thought that was the whole idea, like Track One. I thought Track One was going to be so wildly successful and popular. People were going to love it, and that was going to become the new model, and it just has not. And in my experience, when talking to clients, I haven't represented clients for a while now, but back when I would always tell them about Track One, they would always love the idea. You tell them about the fee, not so thrilled with the fee, but they get it. Okay, that, because it saves time and money. It usually cuts down, in my experience, cuts down at least one office action.
Yeah.
At least one. And so the amount of fee that you pay almost is made up based on that. And the rest of the fee, if it's not made up based on the cost of an office action, should be made up based on, well, I got it in 6 months, not 3 or 4 or 6 years or whatever the case may be. It just strikes me as odd that more people weren't into it. Maybe that's why the patent office didn't try to expand it. But I think that's the model for the future that has to make more sense. Because look, if we're constantly as a society tying these inventions, meaningful inventions, up for 2, 3, 4, 5, 6, 10 years, sometimes cutting edge stuff. It takes a while for examiners to understand. It takes a while for them to become familiar with the prior art. It becomes even longer for them to then be comfortable to say, okay, I'm going to give you this claim, particularly if you want it to be a broad claim in an area that everybody knows is important.
Yeah.
So we can't have the patent office being a bottleneck.
I agree. I wanted to add something on Track One. I've had good experiences with Track One, but you have to play it right. We would do prior art searches. We would find what we thought was the new thing, and then we would draft claims that were not extremely broad, that were reasonably narrow to cover the thing that we thought we were entitled to. Got great results that way. I don't think that's how everybody's using it, but
Right.
when you start with a fair deal in the negotiation, you end up with a better result, and that you can shorten the negotiation essentially you're having with the patent office if you're asking for something that's fair up front. And I think that's where AI has a great opportunity, because you know instantly what's fair. And if the patent office also had an indication right out of the gate as to what's fair, then you can shorten that negotiation significantly and get a better result every time.
Yeah, absolutely. And I also think, too, going for the biggest, broadest, baddest claim that you can get, it's just it's probably never been a good idea. Now it's just, I think, a dumb idea. I won't mention the company, but it's one of the largest 20 companies in the world, probably. I think that's probably fair. One of the largest 50 companies in the world. So a big, huge company everybody would know. And one of the attorneys who represents that particular company, and they do a lot of software stuff, not exclusively, but they do a lot of software stuff, says when they filed the application, the broadest claim is never the first claim.
Yeah.
And it's by design. What they want to do is pick a claim that is representative, that's going to teach the examiner what the technology is and why it's important, and lets them have a dialogue. Okay, well, I think that's brilliant. Maybe not exactly what the rules suggest you should be doing, but I think it's brilliant because it gets people to think about this, right? And then we can talk about, once we understand what it is and what it does, and have good faith belief that this claim set is going to be allowable, well, then I can get certainly more narrow stuff. And then we can talk about, well, how much broader can we go? I think a lot of that, even something that basic, is lost on a lot of clients and a lot of patent practitioners who continue today. I hear, high five when they're able to get a broad claim that is so abstract that it could read on everything.
Yeah.
And then I hear, and I'm sure you've heard it because you have spoken at a lot of our events over the past several years, you hear in-house people constantly saying they want picture claims. I want narrow claims, and I want those narrow claims to cover what we're actually making money selling, whether it's a service or a product. And there is like ships passing in the night between a lot of patent practitioners, what they think is best, and what the client actually wants. And it's not an indictment. Anytime I say things broad like that, it's unfair because there's an awful lot of people that get it on both sides. There are an awful lot of people that don't get it on both sides. And sometimes it's the client that's demanding unrealistic expectations. And sometimes it's the attorney who thinks if I can deliver unrealistic expectations, then I'm going to get more work. I mean, so there's a lot of blame that can go around. But it's descriptively an issue. I think the more sophisticated technology companies want narrow claims. And Gary Michelson, inventor, he invented minimally invasive back surgery and all kinds of things that went along with that, tools and devices. And he, Medtronic finally bought his portfolio for like $1.4 billion. And this is 25 years ago. He told me one time, and he had a reputation as being a patent troll. And he said, I never sued anybody. He said, I countersued. They filed a declaratory judgment motion against me, and then I sued him. Yeah. And he said, but it was unfair in his mind to call him a patent troll. I think that's true. He said, because I never wanted the broadest claim I could get. He said, what I always told my patent attorneys is I want the broadest valid claim possible that's defensible.
Yeah.
He said, because it does me no good to have a broad claim that is going to be invalidated. And I think if that mentality permeated more, that it would benefit the industry. We wouldn't have probably the backlog that we have. Things would go smoother. There would probably be less animosity towards the nefarious actors. And we all know that there are some nefarious actors. Whether you want to call them trolls or not trolls, I don't care. I call them the people who are really the bad actors that are shaking people down for 20 grand a pop. Those are trolls, right? But a lot out on the table there if you want to comment on any part of that.
Yeah, I just think that I agree 100% with the strategy of doing more narrow claims. Now, of course, you have to be cognizant that your client's going to come up, they're going to be upset, in 7 years when there's one limitation that nobody infringes, right. And you said, I wanted picture claims, and that's a problem. So it's somewhere in the middle. But I think that the broad claiming strategy is still so prevalent. And we found this in the data at IP Copilot because the bread and butter, we have a prior art search engine under the hood of everything that we do. And so we test that internally, and it's 90-95% accurate. It's extremely, extremely good. One of the easiest ways for potential customers or clients to evaluate how accurate is this is they look at the face of the patent and they say, oh, did you find the same thing that the patent office found? We actually rarely do. And we looked into that. Why aren't we finding exactly what's on the face of the patent? In small art areas, mechanical art areas where there's a small universe of prior art, we find almost everything on the face of the patent. But in software, fintech, those areas, we don't. And it's because of the broad claiming strategy. Because you file broad claims, you get prior art that's not necessarily related to your invention at all. Mm-hmm. And then you add a little bit to it, and then you get new prior art that teaches the little bit. And then you end up with a 3 or 4 reference 103 rejection, 4 references. None of them are particularly good holistically for teaching the technology that you're going after, but they happen to show tangentially the 4 elements that you have in your claim. Whereas our prior art search looks holistically at the best reference that teaches holistically what the idea is. And when you end up with an examination like that, and you end up with an issued patent, no one's actually figured out. You still have not figured out
what the invention
what the best prior art is. Right. What is the invention, and what is the best closest prior art to that? And then you end up at the PTAB, and then you end up in litigation, and you're trying to figure it out again. And so that claiming strategy ends up with a level of uncertainty that I would not want in an enterprise because I don't know what my portfolio is worth. I might have a claim, but I don't know whether it's valid or not. And then you have to put in an enormous amount of work, if you're going to do it, to figure out how valuable is this actual portfolio.
Yeah, that's interesting. That's insightful. And it actually jibes with my experience too. Whenever I was going through patent searches, and I did a lot of those for people, and not necessarily as the searcher, but going through my process was we worked for a lot of startups, and they were looking to raise money. So we would put together a provisional application would be a piece of what they would attach to their business plan, together with my letter explaining why I thought the invention was patentable and what I thought was patentable and what the prior art was and all that sort of thing. And it was a lot of folks were successful doing that. But in going through that, I was always looking for what are the 3 to 5 references that are the most close to what the invention is.
Yeah.
Because if we can distinguish those and the application is written to actually define the innovation, then I'm feeling pretty good that we're going to get something. I do think a lot of the problems are overbroad specifications, overbroad claims, and I do think at least early on after State Street, when business methods became patent eligible for the first time, there was an awful lot of people doing business methods, which was just another way of saying software. It was like they were Obi-Wan Kenobi. These are not the droids you're looking for.
Yeah.
It was like, here's this process, like a recipe done on a computer. Well, how? Well, it's done on a computer. Did I stutter?
Yeah.
No, you didn't stutter. You just didn't explain anything.
Yeah.
And so I think there was an awful lot of patent practitioners that did stuff that they really didn't understand. They weren't computer people. And that caused a lot of grief. And I wonder whether that still causes grief. Because the people who I know in the industry that do a lot of high-end software work, they tell me they never have 101 issues.
Yeah.
And they rarely have 103 issues that they didn't anticipate. Now, if that's possible, which I know it is,
Yeah.
then what does that say about what's going on elsewhere? And I think a big part of the problem is people are writing these things and they don't know enough about the technology to explain it so that a technologist can, but both a judge can understand it, because that's a very important constituency, and so that a technologist can understand it enough that, well, it's A, it's not B, so I'm going to distinguish over B and eliminate that as prior art. I mean, it's a fine line.
And I think knowing the context of the prior art before the process starts, during the disclosure process with the inventors, is so important, because then you're understanding the technology, you're drafting it into the application, and then you have that process of being able to explain truly what's special about the application. And I think the tides are turning. I talk to a lot of law firms, companies, and there's definitely some that say, we don't want to do prior art searching. Can you turn that off in your product? We don't want to know. Mm-hmm. Head in the sand. And that's fine, because a lot of folks traditionally haven't done it because it's a process you have to add. It's extra expense and there's extra time, and it doesn't fit in. My argument is always, if you could know this instantly for every case, what's special about it, what the prior art teaches, and talk to the inventors about that and design around it. We actually provide a chart that says, here's your features, here's the prior art, and here's exactly what it says. I would love to know, and in my discussion with the inventors, here's what the prior art actually teaches and here's what yours is. Is there an advantage to do it a different way? Let's brainstorm around this and then let's focus on that. Is that commercially valuable to do it a different way? And if it is, let's cover that.
So I don't know any other way that you can do this. I mean, and I know that there are people historically that don't do searches, and I've just had issues with this, is that we don't want to do searches because then if we do a search, then we could be found liable for willful infringement because we knew about this and we did it anyway. And it's like, okay, that to me is like naive on an entirely. So you're going to spend not just the money to file the application and prosecute the application and pay the issue fees and maintenance fees for this thing that you have no legitimate reason to believe is unique because you didn't even look.
Yeah.
And on top of that, you're spending all this time going down this path that may ultimately be taken out like pulling a rug out from under your feet. And you're worried about, well, when was the last time the Federal Circuit let any willful damages stand?
Yeah.
I mean, the law of damages over the last 15, 20 years has gotten worse every year. Every year it's gotten more and more defendant friendly. And Federal Circuit remits or they remand with instructions to lower the numbers. And, I just don't understand. That can't be a legitimate excuse anymore if it ever was. if it ever was, And I think and then on top of that, then you see it's a cascade for a minute to another area is AI and copyrights. You see what's come out in the case against Meta. In the copyright area, that in discovery apparently it has come out that they had a policy that they didn't care whether it was copyrighted. They were going to use it to train their data, and there was consternation among people inside, and they didn't care. So like some of the biggest companies in the world don't care. And Meta, Mark Zuckerberg at one point in time even said their philosophy, I think this came out during the Snap patent litigation, is don't be afraid to copy. If you see something that others are doing and you think we should be doing it, let's just copy it. So if that's your mentality, which it is for a large part of Silicon Valley, and I'm not going to say I don't think it's the best mentality, but that is what they think, and that's fine. But then why are you not doing patent searches out of some fear of willful infringement if you're consciously and willfully doing this behind the scenes anyway?
It's a strange position to take when you're spending over how many willfulness judgments are you going to get over a decade period of time, and how much money are you spending on your patent program during that same period of time? And it's a huge investment for companies. It's tens to hundreds of millions of dollars for the biggest ones. You should want to know where your special stuff is. You should want to get the right answer as to what protection you have for it. And you should want to have confidence that you have strategic assets that are going to be really hard to invalidate at the end of the day. Whereas right now, I don't think if you're not doing prior art searching and you're just filing extremely broad claims every time, you should have almost no certainty that those are going to hold up.
Right.
And so,
you have a front row seat for how expensive this whole proposition is, right? You were Chief Patent Counsel at a time when Capital One decided, well, we don't have enough patents, we need to get a lot of patents, right? You were there then, right?
Yeah, when I started, I didn't know the plan. Ariana had started, I think, 6 months before me. Brandon, who's Chief Patent Counsel now, was he was at Finnegan. He was a secondee at Capital One at the time, and I joined. And the company decided, let's get a lot of patents in a short period of time. And that's it was an expensive undertaking, and I think it was worthwhile because it was a way to inject innovation culture into the company in a big way. That it had a patent program for numbers of years, but it didn't have this culture of thinking about patents first or second. Right. And so it was a good investment, at least from that perspective.
Yeah, but then the maintenance fee bills start to come due, and then that becomes an issue for, I know some of the folks, we've had people, conversations here on this stage about knowing what you should keep, how much do you invest in keeping, all that kind of stuff, and how do you make sure that you don't let the crown jewels slip away or something that could become the crown jewels. It's a big conversation, and it takes up a lot of time, money, and energy to maintain these patents. And so it's not cheap, and you need to get it right. And whether you're getting it right on the front end is a lot harder sometimes because you don't know where the market's heading, you don't know where the technology's heading, and you can be forgiven for filing applications that look promising but then turn out not to be promising. But they sap resources the same as ones that look good. But then somewhere along the way, you need to reevaluate so that you're not throwing good money after bad.
That's true. And just as an example, say you have a case that maintenance fees due, and you got these really broad claims out of the patent office. Do you pay them or not? Are you gonna? Is that claim going to hold up? And it looks really valuable at the outset, but right. Is it actually going to hold up, or are you going to spend millions of dollars trying to assert it and then lose?
Right, and that's what's happening. Yeah, and I think in a lot of spaces it just doesn't make sense to maintain. And I was surprised, and I don't think I know we didn't have the sucking sound that I thought we were going to have after Alice. I mean, once Alice gets issued, I thought for sure that we were going to start to hear catastrophic stories about how the patent office didn't have enough money because the patent office, any given year, it's like 40 to 50% of their budget comes from maintenance fee payments. So people just en masse stop paying maintenance fees. that's going to be a problem. The same thing happened in the mid 2000s, because in the early 2000s, when the Bush administration was in the White House, the director of the patent office cratered the allowance rate, which I thought was bad. But then, as it turned out, 4 years later was a catastrophe because they didn't have any money.
Yeah, that's true.
So all of these things, and I thought that we were going to see with Alice that there was going to be the same kind of level of catastrophe because people weren't going to be keeping the patents, because under a different regime, many of these were just not salvageable.
Yeah, that's true.
I don't think we saw. I know we didn't see it to the level I thought we were going to see it.
I think it's because their bandwidth is one thing. Who has the time to look at the analysis that you would need to, the depth that you would need to look at to say, we paid $40,000 to get this patent, we're not going to pay this fee, and we're going to let that go. And no one has the time to actually have certainty about that decision. Yeah. And the analysis up until recently has been daunting.
So that's where I wanted to go. Up until recently, I mean, do you envision AI playing a much more meaningful role in the decision of what to keep and maintain?
I do. I think that we have a chart product at IP Copilot. We do prior art searching for pre-filing. Mm-hmm. We also can do it for litigation. And then the next logical step is to do for infringement. And I think that it's going to be easier than ever in 3 to 5 years to actually have a really good read on where the hot spots in your portfolio are, where the market is moving, and where you should be continuing investment in things like maintenance fees, continued prosecution, foreign filing. Mm-hmm. And you should have a pretty good idea of that just with the AI out there reading the internet, looking at competitors' websites and press releases, looking at manuals, and then correlating that with your portfolio. That's something that AI is really, really good at. And up until 2 years ago, that wasn't possible.
Right.
But now I think you're going to have a really great indication of where the value in your portfolio lies. And those decisions, you'll have a data-backed decision then. It's not, I didn't have time to look at it, or I looked at it and I kind of have to guess. There's less guessing. And so you have a much more data-backed decision. And I think that you could end up seeing a lower maintenance fees in the areas where these are duds. This is a dud area. The market isn't moving in this direction. Right. And we don't predict the market is going to move in that direction based on filings that we're looking at from the market participants right now. You can correlate where are they inventing right now. And then you can actually make those decisions.
Yeah. The other thing that would help the Patent Office deal with the backlog too is as a part of the AIA, the statute allows the Patent Office to offer deferred examination. And I think you can defer examination under the terms of the statute for 3 years. It's either 30 months or 3 years. But the Patent Office has never really implemented it. They never created rules to let people do that. So that would be something I think that could work a lot, because you see a lot of things, as we were just talking about, that, well, this you thought it was good and exciting when you filed it, but at some point in time you realize, we've moved on. The industry moved on and they didn't adopt this. There's something better out there.
Yeah.
I think that would be a very smart way to go about addressing not only the backlog, but just keeping it in place, right? Because I think, again, if I had my druthers, what I would do is I would want people to file the best specification that they possibly can that describes the invention. All right. Then I would want to wait and see. Okay, am I going to prosecute this? Am I not going to prosecute this? And what claims am I going to want? What claims am I going to get? Well, I should be, based on the law, entitled to whatever claims my specification allows me to have. And I don't understand, to some extent, why I need to write claims and file them at the time. And I know that you don't have to file them anymore, but you got to file them pretty quickly.
Yeah.
I mean, wait 3 years. See if it still matters. File the claims. And then if we put that together with what we talked about earlier about getting everybody in the room up to speed, spending, whatever period of time, like half their time on the allotted for this case in preparation for a negotiation meeting, and see if we can get these things issued one after another right away rather than wait 18 months, 2 years, or longer in prosecution. I think there's an awful lot of streamlining that can be done. And I think if you did it that way, then you would have an awful lot of inventions that looked promising when they were filed wind up not being promising and go away. And people could then spend more money on the stuff that matters.
Exactly. There's a lot of data that comes through in that 3, 4, 5 year period of time where you might defer something, and you can determine where the value lies. And the industry is going to develop. A lot of it is, by definition, brand new technology. Mm-hmm. Examiners aren't familiar with it. In 3 years, there'll be more data, and they'll be more empowered to make decisions on where this particular application should go. And so you're really just empowering the process by waiting a little bit. And you're actually spreading resources around where they matter most, because there's, in the startup world, or even the smaller company world, it moves quickly. Folks are developing products, and it's like the shiny thing this month, and everyone, let's file patents on that and that and that. And then they go out and they test the market, and they get out there and they hear from customers, and sometimes it's a dud. But then you have already invested in this patent application, and you're pot committed at some point, and you say, well, am I going to spend an extra $2,000 on this office action response? Yeah, I already spent $15,000 or $20,000 so far. I might as well.
Might as well.
And you just keep doing it. Might as well. But had you not spent that money yet, you might not.
The decision would be very different.
Very easy to make a different decision.
Yeah. So we could just keep talking. I mean, this is
for
great.
Sure.
The more I do the podcast, the more I understand how Joe Rogan can just sit there for 3 hours and talk to people, because it's really, and you and I we've become friends, and it's just good to sit down and chat with you. But we probably should wrap this up so we don't bore the audience to death. But what I wanted to do before I do that, there was one thing. I always found that you guys with a Capital One past, very close-knit group.
Yeah.
And I refer to them, I think I share with you, you're sort of like the Capital One Mafia, or a part of the Capital One Mafia. Once you've worked there, I've never heard anybody say a bad thing about Capital One while they're there or even after they've left. And I can't help but notice that you all, whether you're there or have left, are friends.
Yeah.
Like real friends. Like when we go to these events and stuff, you choose to hang out with them kind of friends, right? What is the special sauce? What happened at Capital? Was it just that you hired a lot of really good people that gelled? Is it good management? Is it a little bit of both? Is it, everybody's financially doing well, so you're more happy on that level too? Yeah. Or is there some confluence of all of this? If you had to put your finger on it and you were going to try and distill it, what is it that makes that so special?
That's a great question, and it's true. We are all close friends. I'm really close friends with folks who were hired at Capital One after I left Capital One, who I've gotten to know since then. And so I think that the company does a really great job of bringing in folks that have the same culture, and it's a really good culture there. And it's folks that are there for making banking for good. And it's a great culture. I think that the patent program specifically was this massive undertaking to get a large number of patents spun up, build a portfolio in such a short period of time. And I think we had the right mix of personalities to make that happen, and we just gelled extremely well. And coupled with the amazing inventor community that we had, just an incredible community of folks that came together. And you get one-off inventors here or there, but by and large, we had pockets of prolific inventors, many of which work at IP Copilot now. So I founded the company with prolific inventors and friends from Capital One. And I think that all of that together, building this huge program in a short period of time, having so much fun doing it, we did it in the most fun way we could come up with. Because how do you make patenting? Folks are trying to do their jobs, trying to get engineers engaged. So we had a really creative bunch, and we did this really fun process together and built something special that I think will last for many, many, many years. And so I think that's really, it was a bunch of different factors. Right folks, right company, right time. And we've stuck together.
And good hiring decisions, I think. I mean, because I think people underestimate too much, too often about the need to really have a team that gels.
Yeah.
You can get a bunch of the smartest people in the room together, and if they fundamentally don't like each other, they're going to accomplish less.
Yeah. I think that's true. Another thing that Capital One does that's really special, I think, and maybe lots of companies do this, but they did a lot of training for teams to figure out what personality types different folks have, and like how do you get the most out of all of your team members, and how do you have them be seen if they're maybe a little more quiet, or how if they're a little more extroverted, how do you tone them down a little bit? But there's a lot of training on personality and management, and they try and make the best out of every team using that. And I think that in some cases you could have a lot of different personality types, which we had, that don't gel because of that. But if you understand it a little bit more and you allow folks to fit in where they fit in best, I felt like that was a really special thing that Capital One did to train the managers.
Yeah, I just observing it, not ever having worked at Capital One, but observing it and observing you all, I think there's a lot more to be said there. I mean, I almost want to do like a whole panel discussion on that, because it's fascinating as to how you guys have stayed together, you stayed friends, you accomplished an awful lot. You took Capital One from very few patents to a lot of patents, and you managed to seemingly keep the innovators happy inside. You kept the management happy, and you had fun doing it. It's like it's a model that I think people would be interested in hearing more about. So more to say on that, I think.
Yeah, you could do a whole podcast. We could do a reunion show.
We should. Oh my God, I love that idea. We're going to do that. But I really appreciate you being here. And
thanks for having me. Yeah. Thanks, Gene.